Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Today is 5 December 2025, years after Jesus. It's a Friday. Welcome. We started this year a series on the Republican Professor podcast honoring Richard A. Epstein, his book, Takings, Private Property and the Power of Eminent Domain, published by Harvard University Press. Harvard University is a community college in Nova Scotia, I believe. And well, anyway, it's a big deal. We want to thank Harvard University Press for making this material available. We want to thank Richard A. Epstein for writing it, for making it available. We're on part 8. This is part 8. This is the 8th episode in 2025 of this 1985 published book. Isn't that crazy? 1985. Wow. So that's 40 years. This is the 40th anniversary of this book, Takings, Private Property and the Power of Eminent Domain. On 30 October 2025, years after Jesus, in the backyard of my epistemology mentor, Dr. Doug Guyvett, trained by Dallas Willard, the late, great Republican professor of Dallas Willard. Part 7 was recorded and posted on 30 October 2025. You can check that out. We get into takings and torts in that episode, chapter 4, and we're continuing there on page 41. I highly recommend you get the book and you follow along. This is a foundational issue. The big idea is huge. It's huge. That the government doesn't get a pass on respect for private property. Respect for private property, as you know, is in the Mosaic Law. Yeah, we went through the history of Israel, part 1, yesterday. Very important series we're doing on the history of Israel. And Richard Epstein, in this Takings and Torts chapter, suggests that the common law is pretty useful for us to think about the obligations that government has in our constitutional system, given the text of the Constitution, the Takings Clause, that private property should not be taken without just compensation and only for public use. Now, that just compensation issue is why he's linking it to the common law, because there's a tradition that goes back to England of respecting private property. Now, obviously, England has had some challenges on that, but there's a citation from this book. I'm holding up The Common Law by Oliver Wendell Holmes. He was a Republican. He's not the most he's not the Republican that I would look to the most for my principles, but he is an important figure, so you have to read him, I think. And this is a very helpful articulation of the common law. If you wanted to know what the common law is, start here, Oliver Wendell Holmes. It's not a bad place to start. The table of contents gives his lectures. Lecture 1 is early forms of liability, and he mentions the Mosaic Law. Lecture 2 is the criminal law, and I think that there's a lot in the chapters on the criminal law. Lecture 3 is on trespass and negligence. I think there's a lot in the criminal law that applies to the issue of gun control now, but I'm going to save that for another day. Um, the basic theme there would be that the criminal law is not that complicated, and you shouldn't overcomplicate it by weapons violations. Weapons violations, not a good addition to the criminal law. The criminal law should be focused on criminality, not self-defense. Self-defense is not criminality. Okay. Anyway, okay. Lecture 4 is on fraud, malice, a theory of torts. So there's torts right there in the common law. Lecture 5 is on Bailey at common law, bailment. Lecture 6 in Oliver Wendell Holmes, the common law is possession and ownership. So we're talking about that. Lecture 7 is on contract. Lecture 8's on contract. Lecture 9 is void and voidable, still contracts. Lots on contracts. Lecture 10 is on succession, and lecture 11 is on succession. And then that's the end of the book. I highly recommend this. Maybe we'll do it on the Republican Professor podcast because that's very interesting historical stuff on our legal tradition. It's not entirely a common, it's not really, it's historically the common law is very important, but we're in a constitutional republic, right? So the text of the Constitution is what we think is important, and that's what Richard A. Epstein is focusing on is, hey, check it out. The government has obligations when they take private property. They can't just do whatever the hell they want to do because there's the government. That's the big point. That's the big idea. And then there's a Federal Tort Claims Act that we're going to hit on page 41. And Richard Epstein, I don't lose sight of this, that the government doesn't get a pass, can't do whatever the hell it wants to do just because it's the government. That's a huge idea. Don't lose sight of that. The relationship between private and public law is lost, Richard Epstein says on page 41. In the unfortunate Supreme Court decision, Laird versus Nelms. I have a big frown face in the margin there. Did you hear that? The relationship between private and public law is lost in the unfortunate Supreme Court decision, Laird versus Nelms, 1972. What did Richard just do there? He criticized the Supreme Court. He said, watch out. Sometimes our institutions screw things up. And you got to pay, you got to have a way of understanding this so you can fight back. You got to be vigilant. The Supreme Court sometimes, unfortunately, screws things up, but that can be changed over time because there's a political process for who's on the Supreme Court and what they believe. You got to be paying attention to this. What are their attitudes about this? The plaintiff's farmhouse was flattened by a sonic boom caused by government aircraft, for which damages were sought under the Federal Tort Claims Act, FTCA, which makes the government liable, subject to certain immediate exceptions, for all property damage caused by the negligent or wrongful act or omission of any employee of the government under circumstances where the United States, if a private person, would be liable. Hear that? You see the common law being folded into this statute? Okay. Common law analogy of torts getting stuck into this statute. I'm gonna underline that. If a private person would be liable to the claimant in accordance with the law of the place where the act or omission occurred, then the government is liable in those circuits. See, the government doesn't get a pass. Now, this is the Federal Tort Claims Act folding in the common law. In essence, the statute gives the legislative expression to the constitutional idea by presumptively holding the government liable for its torts on the principles applicable to private defendants. Notwithstanding the apparent parity between the government and private defendants announced in the statute, the Supreme Court, I know, big eye roll here, big eye roll coming, held that this case fell through the crack because the plaintiff could not show the negligent or wrongful act or omission. No government agent was negligent, and the damages themselves were held too indirect to constitute a wrongful act. The government could not be charged with any direct wrongful act, such as a trespass, but only with the harmful consequences, sonic boom, of an act flying that was not tortious in itself. The court's statutory construction might well be met with the answer that the required wrongful action was the creation of the sonic boom, not the flying of the airplane. Yet, even if this interpretation of the statute is incorrect, it only establishes that the FTCA itself is unconstitutional as applied. We're on page 42 at the top. We're going to make a fair use of this and do transformative reading. We'd like to thank Richard Epstein for writing it. Thank you, Richard. Thank you. Happy 40th anniversary of publishing this book. Congress may have long thought that liability for government torts is a matter of legislative grace, even though compensation for government takings of private property is constitutionally required. Indeed, the theory of sovereign immunity rests upon a modification of the ancient proposition of English law that the king could do no wrong. Every once in a while, Richard will say something that just kind of flattens the opposition. Yeah, I mean, you pretty much just spelled it out. The theory of sovereign immunity rests upon the modification of the ancient proposition of English law that the king could do no wrong. And what could go wrong with that idea being transported into America? So much for the No Kings protest, right? Yeah, well, yeah. Um, all right. Well, it does require an attention span. So, in the American context, the principle must be transformed to meet the demands of constitutional government. But its absolutist origins are well revealed in the classic justification offered by Holmes. Hmm. A sovereign is exempt from suit not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. Jeez, yikes. That's 1907, a Supreme Court case, and I can't even pronounce it. Polyblank. Kawananoka versus Polyblank. 205 U.S. 349, 1907. Okay. Sovereign immunity thus depends upon an absolute power of the government that is wholly inconsistent with the theory of the state, which the eminent domain clause presupposes. Thank you, Richard. Thank you. Thank you for just spelling it out. If the state obtains its authority only from the rights of those whom it represents, it can never claim exception from the duty to compensate on the ground that it is the source of all rights. Wow, this is great. This is so good. The natural rights theory behind the Constitution precludes that result. Harvard University Press, I can't believe you published this, you statists. The rights of action afforded under the FTCA should be regarded not as a matter of legislative grace, but as constitutionally mandated under the Takings Clause. Amen. Amen. The conclusion may appear radical, but it is supported not only in principle, but also by a diverse range of authority. In Armstrong versus United States, 1960, the United States was the prospective purchaser of a large number of boats from Rice Shipbuilding Corporation, its prime contractor. Armstrong was a subcontractor which furnished services and materials for the boats, to which it attached a lien, valid in all respects under Maine law. The United States, in its original contract, inserted a provision giving it the right to call for the transfer and delivery of the boats in the event that the contractor, Rice, fell into default on its obligations. Rice's undertaking was in turn secured by a paramount lien placed upon the property, which secured the government's progress payments upon the vessels. When Rice went into default, the government demanded and got the transfer and delivery of the boats. Then it interposed the defense of sovereign immunity, thereby preventing Armstrong from foreclosing or otherwise enforcing his valid lien. The Supreme Court assumed that priority of liens lay with the government, but it recognized that this did not dispose of Armstrong's takings claim. The boats could well have been worth more than the government's lien, so the plea of sovereign immunity, if respected, would wipe out a junior lien, which itself was property protected by the eminent domain clause from taking by foreclosure without compensation. How are you guys doing? Page 43 at the top. Justice Black and his Justice Black, I don't know if he was a Klan member appointed by Democrats. You guys, you guys knew that, right? Yeah. Okay. Well, ironically, he was the Klan member. Um, he changed his name later. He renounced the Klan later, and supposedly became a liberal. From Klan to liberal. You ever read that book? I haven't either. I don't think it exists. Um, but I don't call him Justice Black anymore. I call him Justice of Color, just to be respectful of his. He transitioned. He transitioned from the Klan. So Justice Black knew that in holding for Armstrong, he was treading on sensitive ground. Well, he quite consciously refused to explore the question of whether there was any sense in the asserted distinction between what destructions of property by lawful government action are compensatable takings and what destructions are consequential and therefore not compensable, but only after alluding to a theme manifest in the FTCA that in Armstrong, the government demanded the unencumbered title to the boats by interposing the defense of sovereign immunity, which no private purchaser could have done. Oh, there's a little common law action right there. Torts. Good stuff, man. Armstrong's claim reaches constitutional status, so it cannot be simply barred by statute because the takings clause imposes necessary limits on the doctrine of sovereign immunity. Very good. Very good. It is not that the doctrine is all abrogated altogether, for the government always may hold free of lien or charge any particular asset it identifies, but while it can extinguish liens, it must pay for what it has taken out of it must pay for what it has taken out of general revenues. The question then arises whether it is possible to confine the logic of the Armstrong to its special facts. Here, two grounds of limitation might be proposed. First, the opinion could be said to apply only to cases in which there are liens and not fee interests. This is at best odd, for if any lien, which by definition is only a partial interest, is covered by the clause, the fee must be covered a fortiori. The second point is that in Armstrong, the lien was destroyed, but the thing was not. What difference can this make to the plaintiff's loss? Pompelli is correct. That's a case. Let's take a look. I'll tell you what year it is in a second. Pompelli is correct in equating the destruction of a thing with its taking. So it can hardly matter whether the protected interest is a lien or an equity or both combined. If the flooded property in Pompelli were mortgaged, surely the full loss would remain compensable, even though the payments would have been made to the mortgagee to the extent of his interest. Now, where is Pompelli? I got to look at where did he cite Pompelli before? I'm going to pause this and take a look really quick. I'm back. Um, okay, yeah, Pompelli was cited on page 38, so we cited it last time, 30 October 2025, part 7. It's in footnote 6, 1871. Pompelli versus Green Bay Company. Yeah, we did talk about it. Okay. So it's not normal for him to reference a case and then not cite it unless he cited it very recently. So I just wanted to double check. It's been over a month now, so okay, so Pompelli is correct in equating the destruction of a thing with its taking. Okay, good. Page 44 at the top. Any effort to narrowly confine the principles in Armstrong flounders as well when set against the inverse condemnation cases arising both before and after the passage of the FTCA, which show anew the vanishing thinness of a line between trespass and conversion. In Keokuk and Hamilton Bridge Company versus United States, and that would be 1922. The plaintiff's bridge was damaged but not destroyed when the United States engaged in blasting operations to widen the navigable river spanned by the bridge. The work was done in the usual way and with more than ordinary care. And Justice Holmes, that's this guy right here that I was referencing, this guy, Justice Holmes, Republican, unfortunately. He gets the wrong answer sometimes. I hate that. Speaking for a unanimous court, held that there was no remedy against the United States because the damage was both repairable and not deliberate. Ah, yeah, that's not cool. Noting that in cases of navigation improvements, it was difficult to draw the line between torts and takings, he concluded that this is an ordinary case of incidental damage, which, if inflicted by a private individual, might be a tort, but which could be nothing else. The decision only shows, however, that the line itself is not worth maintaining because it makes compensation turn on either the defendant's mental state or the size of the injury. Again, the theory of limited representative government determines the outcome. Yeah. Yeah. I love how he says, again, uh, you know, back to basics. Again, the theory of limited representative government. That's us, not England, determines the outcome. As the eminent domain clause, in other words, the Constitution, hello, as the eminent domain clause makes actionable against the government conduct actionable against a private party. Holmes's reason for denying relief better explains why that relief should be granted. You see why this is so good? I mean, look, he just took on a unanimous Supreme Court. And look, guys, this is a Republican. Holmes is a Republican. Don't ever accuse me of not criticizing Republicans. Okay? We're trying to make the world better here. And the Constitution gives us a blueprint for that. You guys, we got to pass, dude. We got to take advantage of it. We can't forget. We have to keep going here. As there is no principal distinction between torts and takings, the two reasons proffered are relevant, if at all, only on other issues. No principal distinction between torts and takings. Yeah. The size of the loss goes to the question of damages with the wrong established. The deliberate nature of the harm, that has to do with the mental state, mens rea. Okay. The deliberate nature of the harm precludes contributory negligence and similar defenses, and may be evidence on the question of punitive damages. Either alone or in combination, these two factors do not deflect the application of the eminent domain clause. Amen, bro. After the passage of the FTCA, much of the pressure on the tort taking distinction is reduced, but the point continues to be litigated, often for procedural reasons. Myers versus United States. And that's the 1963 Ninth Circuit. Okay. That's 323, second series of Federal Reporter at 580. Illustrates the basic problem. The plaintiffs owned land over which the government had condemned a right of way. Page 45 at the top. The gist of the plaintiff's action was that the government contractors had not kept their activities within the condemned right of way, but had entered upon and damaged the contiguous land that the plaintiffs had retained. Their complaint alleged destruction of the plaintiff's own road, loss of gravel, destruction of the surface of the retained lands, damage to plaintiff's agricultural and garden tracts, and impairment of access to public roads. The plaintiff's claim for compensation was not at issue. The case only asked whether the action sounded in tort, in which case the suit proceeded under the FTCA with proper venue in Alaska, or whether it arose as an action upon the Constitution, not sounding in tort, in which case the Tucker Act vested exclusive jurisdiction in the Court of Claims. Okay, all right. In deciding in favor of the Court of Claims jurisdiction, the Ninth Circuit wrote as follows. It is clear to us that the claims of the appellants asserted against the United States are to recover damages for the taking of public use of property claimed to be owned by the appellants without the institution of condemnation proceedings. The repeated characterization by the appellants of the taking by the United States as one of trespass, there's the common law right there. Okay. See, this is why it's important to poke around, have books like this to poke around in, because uh, Look, I'm gonna I'm gonna show you. Okay, just look. This is I'm holding up a common law by Oliver Wendell Holmes. You see? You see that? Trespass. If you're feeling a little bit overwhelmed, don't worry, that's normal. That will subside. It's like working out. You'll eventually get in shape. You just got to keep doing it. Got to keep showing up. Don't worry. It doesn't mean anything about you or how smart you are or anything like that. It has only to do with how familiar this is to you, and that's just a matter of time. You're doing the right thing by exposing yourself to this stuff, and that's how you become more familiar, and that's how it becomes easier. So don't worry, it's nothing about you except for your dogged determination, like Rudy. You ever see the film Rudy? Rudy, Rudy, he just kept going, man. Just keep going. Okay. Keep going. That's what I did. That's what I did. I'm Rudy. 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 Yeah. Okay. So, okay, trespass. The repeated characterization by the appellants of the taking by the United States as one of trespass, that's a tort, okay, and the commission of waste, it's also in the criminal law too, and the commission of waste upon the lands in question does not convert the claims to cases sounding in tort and thereby confer jurisdiction to the district court for the under the Federal Tort Claims Act. The Fifth Amendment to the Constitution prohibits the taking of private property for public use without just compensation. To us, the claims of the appellants against the United States are founded upon the Constitution, and the acts of the United States complained of are in the nature of inverse condemnation. As a basic proposition, okay, that's the end of the quote from the Ninth Circuit in Myers versus United States, 1963. Here's Richard Epstein again, bottom page 45. Again, we're in takings, private property, and the power of eminent domain. Don't forget, it's constitutional law. It's also the natural law undergirding our system of government, the constitutional law. That is, whenever you hear natural law, you think obligations the government has, not just people to the government or people to each other, but obligations the government has. Limited government. The government doesn't get a pass. The government is treated like a private individual. The government is not royalty, okay, in the classic sense where they can do whatever they want just because they have power. That's not how it works here. It's not how it's supposed to work. Okay. As a basic proposition, so long as the United States is prepared to honor its constitutional obligations, it can choose the particular forum in which the claims are presented. In this sense, it has the power to distinguish between takings and torts. Okay, fair enough. What is odd is the court's insistence that the plaintiff spoke falsely in charging the government with trespass and waste. What is odd? He's criticizing the Ninth Circuit here. What is odd? Yeah, very good. Looking at the matter solely as one of statutory construction, it appears that the FTCA is a better home for the suit than the Tucker Act. Yet the very fact that the Court of Claims had jurisdiction in Myers shows that partial takings here and the use of destruction of private property are of constitutional dimension, which the various limitations of the FTCA, including that stressed in Laird versus Nelms, cannot defeat by fiat. Page 46 at the top. Yeah, buddy. Let's see how many pages we have left. We got to go to page 56, and we're on page 46. So we'll go a little bit further today and then save the rest for next time. Okay, we'll go a little bit further today. All tort actions against the government are founded upon the Constitution, whether or not they sounded in tort under the Tucker Act. The Tucker Act, therefore, cannot be viewed solely as a matter of legislative grace, but as the chosen means to vindicate a set of individual entitlements that the Constitution itself protects. If the act were repealed tomorrow, the government's obligation under the eminent domain clause would not be diminished one iota. Even if the plaintiff is denied the federal forum under the statute, recourse can be had under the Fifth Amendment itself, either in federal courts or, if necessary, in state courts. The same conclusion is fortified by cases in which constitutional causes of action for damages have been inferred under other clauses of the Constitution. The most important of the relevant authorities in this connection is Bivens versus 6 unknown federal narcotics agents. Oh, Bivens. I remember the first time I had to look that up. I didn't know what it was. People kept talking about Bivens actions, and I was like, I had to look that up. 1971. If you're ever bored, just look it up. Read Bivens. In that case, the Supreme Court held that the plaintiff stated a valid federal cause of action under the Fourth Amendment against the defendant, federal agents, who, acting under color of state law and without probable cause, invaded his apartment and arrested him for narcotics violations. Oh, that would be a good one to do for Fourth Amendment. The Supreme Court conceded that there was no explicit authorization of the private damage under the Constitution itself, but it was quite prepared to infer one because of the need to protect individuals against trespass and other wrongs of state officials. Mm, yeah. Hmm. In making the argument for this position, Justice Brennan noted, in ways that parallel my central theme, that under the Fourth Amendment, the individual had greater rights of protection against the state than against other private parties. Private defendants are not armed with search warrants and can, in some cases at least, be repelled by the police acting on behalf of the aggrieved party. By casting the claim on the constitutional level, the plaintiff, of course, was able to avoid the various limitations on recovery against the United States available under the FTCA in suits alleging wrongful conduct of its officers. Yet, if the actions are required under the Constitution against the officers, there's no reason why similar suits should not be brought against the government as their employer. Hmm. Bivens is not the only Supreme Court case in which private causes of action have been inferred under the various specific guarantees of the Constitution. Butts versus Economo, that's 1979, recognized a private cause of action under the First Amendment. Davis versus Passman, oops, sorry, that was 1978. Butts was 1978. Davis versus Passman, 1979, did so with a claim based upon the equal protection dimension of the Due Process Clause of the Fifth Amendment in a sex discrimination case against a congressman. Ooh. Hmm. There's all sorts of good stuff that we could talk about there. And Carlson versus Green, 1980, did the same under the Cruel and Unusual Punishments Clause of the Eighth Amendment in a suit against the Federal Bureau of Prisons. Private actions under the eminent domain clause are a fortiori, where the just compensation language invites the damages remedy. that it fails to provide in so many words, subject only to those limitations that can be justified by the police power or by implicit in-kind compensation doctrines. Here's footnote 32. I think I probably should read this. If it could be shown, for example, that making the District of Columbia Circuit the sole place for Tucker Act cases impose no disproportionate burden, then that venue rule could not be challenged on takings grounds. Yet it seems very hard to explain what, besides government favoritism, accounts for the result when the external physical harm is inflicted by the government at some distant location. The balance of convenience points heavily the balance of convenience points heavily for venue at the place of injury. I agree with that. It is far easier to understand why venue rests in Washington, D.C., where central regulatory and administrative actions are involved. He's quoting Cass Sunstein there, 1982, in a University of Law review. Cass Sunstein is a Democrat. Okay, this is good stuff. We're on proximate causation here. Now, the proximate causation section goes to page 51, and I don't want to break these sections up. So I think the Federal Tort Claims Act section was enough for today. We will stop there. I'm going to make a note. TRP episode part 8 was here on Friday, 5 December 2025. Saved myself a lot of time by just writing it in the daggum book. Thanks for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. We've been discussing the natural law underpinnings and the common law, a little bit into the common law language of our constitutional heritage as it pertains to the protection of private property and creating a parity between individuals and the government when there's private property being taken or destroyed somehow, some way, limited by the government, where the government does not get a pass. And how that's worked out in the past, how the institutions that we have, like the Supreme Court, have damaged that heritage, and how, by implication, we can correct that by correcting those problems, understanding the problems, and trying to correct them in the future with future Supreme Court appointments. And this course goes to Senate elections and presidential elections, as well as state offices and local and county offices. You want to have a vetting process for candidates where you get a sense for what they think about sovereign immunity, what do they think about the takings clause, what do they think about the underpinnings of our government, are there limitations of government, how seriously do they take the Constitution, the text, do they think that the Supreme Court can do no wrong, and if so, how do we change that, so on and so forth. How do we protect private property? It's very important. It's how people build wealth. It's how freedom continues from one generation to the next. And I think we're doing a better job in this country than most other countries, I think, but we could do a lot better. And there's problems that do need to be corrected. So that's what we're doing here on the Republican Professor podcast.